I just want to ask of the court if you're intending to take up his inmate communication form that was dated September 28, 2022 as well, while Ms. Wollenhop is on the stand. I just have a few questions related to that, Your Honor.
I object to that. Relevancy. What does it have to do with what she's testifying to right now today? They're two separate issues.
I'm sorry, I don't know the document. Oh, I do have the document number, 258.
Objection for relevancy.
Hold on, Mr. Brooks. I need to find the document in my record. 258, you said?
Yes.
I'm just going to print that off for ease of my reference. I am going to allow the jail administrator to be questioned regarding document 258. I don't know if Mr. Brooks has a copy of that in front of him or not, so I will print it off in that courtroom.
So that he has that.
So that I have this correct on the record, you're making a judicial determination to allow testimony of something that has no relevancy to what's being raised today. How do these are two separate issues?
The court recognizes that they're two separate issues, but I also have the authority when considering judicial administration and economies of scale, shall we say. We have the jail administrator here. It's an important housekeeping issue as we go forward. And so I'm going to address it after I address the motion to adjourn that you filed, but since we have her here, I'm going to have the parties question her on that document as well. It promotes judicial economy, and that's my decision. So go ahead.
Can I put Your Honor on notice that I intend to appeal that decision?
Your statements noted of record. All right, go ahead, Attorney Opper.
All right, Ms. Wollenhop, I don't believe you have the document in front of you, but thank you,
The
Judge.
record to reflect, I'm handing her a copy of what is in the record as document 258.
Thank you, Judge. I'm sorry.
That's okay, I'll print off another copy for myself.
Okay.
Can someone confirm whether that document was given to Mr. Brooks as well? I did print it to the printer over there. I have that ability. It was. All right, thank you. The record to reflect, he has also been provided with a copy of docket number 258.
I'm not acknowledging that document, Your Honor. I'm not acknowledging that. I don't consent to any.
All right, I'm going to mute him because he's interrupting. Mr. Brooks, it's a document you filed. So, and it's a document that was filed through the inmate communication form process. It was scanned in on October 3rd, but it's dated 9/29, and it's directed to either clerk of court / Judge Doro. So go ahead.
Thank you. Ms. Wollenhop, you've seen a copy of this document previous to today, correct?
Yes, ma'am.
And you're aware that
It's dated September 28, 2022, correct?
Correct.
And purports to have been written by Mr. Brooks himself, correct?
Correct.
And in this communication to the court, Mr. Brooks indicates that he is on a, quote, keep separate, end quote, in the jail, correct?
Correct.
And at the conclusion of the form,
near the bottom, the last two sentences, he indicates that he has no access to the materials he needs to prepare for trial because of the keep separate order, correct?
Correct, that's what he states.
Okay. Is that a truthful statement? Well,
It
let
is.
me ask a different, that's a bad question. I strike that question. Did Mr. Brooks have access to his legal materials during the time that he was under a keep separate order?
Yes, ma'am.
Again, that would be the banker boxes of written discovery in his own jail cell?
Correct. Anything that was in his jail cell, he would have access to.
Okay.
And he would also have access to the conference room and a tablet.
And the
in his
tablet.
cell.
Okay. And that's the legal materials that are provided to him are on that tablet and on the computer in the conference room.
Correct.
And nothing about that keep separate order affected his ability to access those things, correct?
Correct.
Thank you. I don't have any other questions on this topic, Your Honor.
All right, Mr. Brooks, I will unmute you. Do you have any questions on this topic for the jail administrator?
Yes, I do. You just stated on record that I had access to all materials for trial prep during the time of this keep separate, correct?
It doesn't specifically say what you don't have access to, so yes,
No, I
what was
said,
in your cell.
Did you just say in open court on the record that I in fact had access at the time of this keep separate?
2 items in your cell, and you could have access to the conference room to view electronic legal materials.
So, am I correct in saying that when you brought over these discovery materials to the pod, that I was in fact in one of those conference rooms and I talked to you face to face, is that correct?
You were in a conference room and we spoke.
And I informed you then that I was on the keep separate, correct?
I do not recall that.
I specifically told you that I was on a keep separate with the guy that was in the cell next to me that had placed that on me, correct?
I do not recall that.
So you don't recall, you can recall that we spoke, but you can't recall what we spoke about.
I informed you at that time I was delivering the banker's boxes.
And I took the liberty to explain to you that I was on the keep separate and that that was gonna hinder me being able to prepare. Is that correct?
I do not recall that.
You don't recall that, or you don't remember me bringing it up?
I do not recall us having a conversation regarding the keep separates. We had a conversation regarding me delivering your legal material.
So, is there a way to verify when the keep separate went into effect?
Objection relevance?
Well, hold on. Mr. Brooks, as I read this inmate communication form, and perhaps it's just a simple question, when you wrote it, did you have access to the banker's box of materials yet?
No, I did not. Ms. Wallenhoff just testified the last time that she gave testimony that she brought the discovery materials over on Thursday the 29th. She did say that in open court on
I
the
agree.
record.
Yeah,
This-
she said that
this-
previously.
This inmate request was written on September the 28th. At that time, I was already on the keep separate protocol, which does not allow me to come out of my cell.
But is the issue that keep separate protocol, or that you didn't have access to the materials that we've now established through testimony you had access to once they were delivered to you?
The keep separate protocol in itself, Your Honor, restricts the 2 people that have the keep separate from being able to come out of their cell until one of them is moved. Whether that be to another unit in the pod or a different pod, that part I can't speak to, but neither of the parties are able to come out of their cell until someone is moved. And the reason why I wrote initially why I wrote it was because that stops me from being able to shower in the unit, because officers will have to then take me to another part of the jail, sometimes in the pod, in a secure shower is what they call it, which is downstairs. in
Sir,
another
I'm just
unit.
gonna stop you because I honestly, the whether you have a shower or not is not relevant to the issue of whether you had access to the materials you need to prepare for your case. So I read this inmate communication form, especially that very last sentence. I am respectfully asking and requesting that my trial be slightly delayed as I have no access to the materials needed to prepare for trial. Thank you. So my question to you is, and I think you've already answered it, but I want to make sure, at the time you wrote this inmate communication form, the materials had not yet been delivered to you. Is that your testimony?
The boxes that were brought over had not yet been delivered. I had already had maybe 10% of the discovery materials that was provided to me by my former attorneys on this matter.
Right. So
That in itself was very, very voluminous in itself.
Sir, we had a prior hearing related to the access provided to you and when the materials were provided. You may recall that Attorney Perry even testified over Zoom audio about that. The jail administrator testified as well. To me, that record is very clear that the materials that were provided by your defense attorneys following their discharge on your case were received by you on September 29th of 2022. That has been established. No one is disputing that. So that's the record that I have before me. I understand what you're saying about the keep separate, but also at that hearing, it was made very clear to everyone that the jail administrator gave some specific directives as it relates to you and access to certain things.
I do recall that, Your Honor. And one of the questions, if you recall, one of the questions I had about what you just said was, did all the officers know about that specific order, I guess it would be called? I don't know what it would exactly, but the information that was to be passed down from Ms. Wallenhoff to the officers.
Right, and I'm not going to revisit that because you were given ample opportunity when we first addressed that to ask questions and to provide other information, meaning statements from yourself. And the clear record from that is that the information was put into the jail management system, it was documented, and that the jail administrator had no information to suggest her employees did not have that information and honor that information. There was no testimony from anyone else to suggest that that wasn't followed. So,
I would like to say something for the record, Your Honor, on that.
go ahead.
To speak to what you just said on that, it's possible that all officers were not aware of that. I even talked about this with an officer who worked just last night that wasn't even aware. And his answer was that he had been off for a few days, so to his knowledge, he wasn't aware of that. And that issue came up because I specifically asked to utilize a tablet. So in my mind, that would say to me that I'm not trying to argue if the order went out to the officers. That's not what I'm disputing. I'm just disputing the fact that every officer that works in my pod is aware of that.
All right, thank you. Any questions at this point for the jail administrator? Again, not related to the shower, but related to access to materials.
Does a keep separate protocol, Ms. Wallenhoff, does a keep separate protocol restrict inmate movement in any way?
Objection, relevance.
Sustained. Overly broad. Next question, or rephrase.
Does being on a keep separate protocol, or rather, should I refer to myself? If I am on a keep separate protocol, would that, in effect, limit me to only being in my my cell and being able to only utilize what I would essentially have in my cell.
That's a compound question, so you have to break it down one at a time. So rephrase.
Would a keep separate protocol restrict me to cell confinement until arrangements can be made for me to be able to resume my normal activities?
Judge, I would prefer not to answer that. It's due to jail operations. We would look at each individual in each situation. I think it's overly broad.
Mr. Brooks, I'm going to honor the request of the jail administrator to not answer that because it would require her to provide information regarding jail operations. It's overly broad. You need to limit the question to how this protocol limits you, specifically as it relates to access to materials needed to prepare for trial. Not generally whether you're on any kind of restriction, whether, but the focus is how this impacts your ability, if at all, to access materials needed to prepare for trial. Other than we've established that you didn't have the materials from your attorneys that were provided after they were discharged by the court until September 29th. I mean, we've established there was a gap, right? I granted the motion and allowed you to represent yourself on the 28th. That was a Wednesday. And then the materials, even though they were turned over to the jail, it sounded like in the evening on the 28th, there was protocols in place to go through that. And then those were provided to you on the 29th. That is well established on the record. So I understand that. We've addressed that in part previously. So I know the state wants me to address this, and I think I know the reason why. But if there's any question you want to ask the jail administrator about what was going on the 28th or 29th, or even going forward, that would impact your ability to have access to these materials, that's the type of questions you need to ask, okay?
Well, I asked the question and I was told that it wouldn't be answered. I asked at the time that she brought over the discovery materials, was she aware that I was on a keep separate protocol at that time?
Asked and answered.
Sustained. The answer was already provided. She doesn't need to answer it again. Next question.
What was the answer to that?
The record speaks for itself, sir. Next question,
I don't
please.
recall her answering that specific question.
Next question, please.
Can you provide for me where she answered that specific question?
Mr. Brooks, do you have another question for the jail administrator?
Is it going to be answered? Is it going to be honored?
The record speaks for itself, sir.
Well, if the record speaks for itself, then that question should be able to be answered. Were you aware, Ms. Wallahop, that at that time I was on a keep separate protocol? That it was already in the system that I was on that protocol?
What date are you referring to, sir?
The date that you brought over the discovery materials, were you aware at that time, on that date, that I was under a keep separate protocol?
You previously asked me if I recall the discussion you were informing me.
But that's not the question now, though.
I was aware.
The question is the day that you brought over the discovery material, were you aware at that time that I was on a keep separate protocol?
I can't state for certain at that moment in time. I was aware you were on a keep separate. I can't state what day that I was made aware of that. I think it was due to a complaint that you sent forward to the jail.
I sent no such complaint. The complaint was by the other party. Were you aware of that?
Judge, I prefer not to answer this. I don't understand how it impacts what he has
Mr.
had
Brooks, we're
access to.
far afield from the issue at hand, so I'm going to ask you one last time, do you have any additional questions for the jail administrator?
What are you allowed and not allowed to do on the keep separate protocol?
Objection, relevance.
Sustained. All right, then, I gave him the opportunity to ask questions, that was his last one.
I wasn't done.
Mr. Brooks, I'll give you one more opportunity then. They need to be relevant, they need to be within the bounds that I've already discussed.
That was in the bounds. I just asked this.
The issue is limited to the impact of the keep separate on your ability to have access to materials needed to prepare for trial.
But Your Honor, with all respect, every question that I asked that had relevancy to that was either overruled or she was directed not to answer that.
Mr. Brooks?
So
Mr. Brooks, you indicated you had other questions. I will give you this opportunity if you can ask a question that falls within the scope that I've previously identified. Do you have another question?
Would I be allowed out of my cell on a keep separate protocol?
It's vague, Your Honor. The question is, was he allowed out of his cell to access his legal materials?
That's not what I asked.
Right, the question you asked, the objection is sustained. If you'd like to ask the question suggested by Attorney Opera, that would be permissible by the court.
No, I would want to ask my own question. Thank you. Was I able to come out of my cell on the keep separate protocol?
Judge, I would prefer not to answer that.
It's beyond the scope of the inquiry right now. The jail administrator need not answer that question.
Can you give me the basis why, Your Honor?
It's beyond the scope.
What does that mean? I do not understand.
Mr. Brooks, do you have any other questions?
I do not understand what beyond the scope means. That was a direct
One last time,
question.
sir. Do you have any other questions?
That was a direct question.
All right, I'm going to mute him because he's now not being responsive to the question that I asked, and that is, does he have any questions to ask the jail administrator within the scope that I've previously outlined? Any follow-up from the state?
No.
All right, thank you. You may step down. All right, does the state have any other witness or evidence you want me to consider related to either of these issues, the motion to adjourn or the inmate communication form dated September 28 of 2022?
Nothing else from the state, Your Honor.
Mr. Brooks, do you have anything else related to the inmate communication form dated September 28 of 2022? Since we obviously included that after we took up the other issue.
Yeah, I don't understand how any questions that I was asking are not allowed to be answered.
Mr. Brooks, I'm asking you very clearly, do you have any other information, testimony, or evidence you want to present as it relates to the inmate communication form dated September 28 of 2022?
Yeah, I would like to. Is it a way that we can verify the standards of the keep separate protocol?
Mr. Brooks?
To be able to show the
Mr.
court.
Brooks, please listen very carefully. There's a question I'm asking you is, do you have any other evidence?
I don't consent to being asked a question.
Document? All right,
when
then
you
I'll.
can't even answer the
All right,
question
I'm going
without
to mute
asking
him
you.
once again. He is not answering very clear questions. I asked him if he had any information, evidence, testimony, documents he wanted to present. Instead, he asked me if I could verify, and that is not within my role. This is an adversarial system of justice here in the United States and in Wisconsin. I preside over that, but it's up to the parties to present information, evidence, testimony to the court so that the court can address the requests and make decisions.